Kotol 12, Shripad sir, Kotol 12.
Yes. ಬರ್ತಾ ಇದೆ.
The video clear ಇದೆ ಅಲ್ಲ sir?
ಹೌದು clear ಇದೆ.
Okay sir, thank you sir.
ಬೇಕಾಗಿಲ್ವಪ್ಪ ಹಾಕೊಂಡು ಬಿಡ್ತಾರೆ ಅದೇ ಬರುತ್ತೆ ಆಮೇಲೆ ಹೋಗಿ ಹಾಕಕ್ಕೆ ಈಗ ಎಸಿ ಎಲ್ಲ ಹಾಕ್ಬಿಡಪ್ಪ ಎಸಿ ಹಾಕು. ಸೊನ್ನೆ 38 8 58 8 92 ಆ ಕಡೆ ಲೆಫ್ಟಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೈಕೋರ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಎಲ್ಲ ತೋರಿಸ್ಬೇಕು. ಟೋಟಲ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ.
Page wise adjournment, list number 2, page number 1, serial number 1 to 3, page number 2, serial number 4 to 8, page number 3, serial number 9 to 15.
Yes. Yes. Office is directed to secure original records from the tribune. Yes. One time. Yes. Call this matter along with that so and so. Yes. Setting up the photo. Color file, but yes.
Minor one submission.
Now that
Sir, one nimsha.
you have filled in Wakalat. Why it is not accepted? Notice is not yet ordered. Then we'll issue. I think we'll call that matter along with that. Then we'll say yes, directed to take notice. Yes.
Minor one submission.
Yes.
Second list serial number 11 ನಲ್ಲಿ ರಘು ಅವರಿಗೆ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಂತೆ.
Yes. Yes.
ತರಿಸ್ಕೊಂಡು ಕಾರ್ಡ್ ಮಾಡ್ಬಿಡಿ.
Yes.
Page number 4, serial number 16 to 22.
Sir, 22, my lord. 22.
14. Call this matter along with that so on. Yes.
22, my lord.
Yes. Yes.
United Insurance, my lord, Janardhan Reddy has filed appeal, my lord, MFA 5176 of 2021.
Yes. Office is directed to show the name of Janardhan Reddy is directed to take notice for respondent number 2. Release this matter along with that so on.
5176 of 21.
Yes.
Page number 5, serial number 23 to 28. Page number 6, serial number 29 to 35. Page number 7, serial number 36 to 41.
Yes. What you want? You are appearing for? You want time? Yes, at the request of counsel for the appellant, release this matter after 2 weeks.
Page number 8.
My lord, serial number 43, my lord.
One nimsha.
You are seeking? Why that? Who has filed a memo for withdrawal amount filed by?
Page number 8, serial number 42 to 47.
I am for serial number 43, my lord. I am for the appellant. Only grants weeks time, my lord.
Yes, at the request of counsel for the appellant, release this matter after 2 weeks.
49, my lord.
44, 2 weeks.
49, my lord.
49, yes.
I am appear for respondent number 1. I informed the appellant counsel 2 weeks, my lord.
At the request of R1, 2 weeks. Yes. Yes. 46. At the request of respondent number 3, release this matter next week.
Page number 9, serial number 48 to 55.
54. Yes, at the request of parties, release this matter after 2 weeks.
Page number 10, serial number 56 to 62.
62, yes. Yes, at the request of counsel for respondent number 2, release this matter of 2 weeks. 60. Yes. At the request of council for R1, release this matter next week.
Page number 11, serial number 63 to 67.
My lord, serial number 65, my lord. Kindly have it next week, my lord.
65.
Yes, my lord.
65, you are appearing for?
Appellant, my lord.
At the request of council for the appellant, release this matter next week. 63, yes. At the request of council for the appellant next week. 60? At the request of council for respondent, serial number 64, at the request of respondent number 1, release this matter after 2 weeks.
Page number 12, serial number 68 to 70. Number 1, hearing interlocutory application matter, serial number 1 to 11.
Please.
Page number 2, for order, serial number 1.
My lord, I am for the appellant. I pray 2 weeks time to take steps, my lord.
Yes, 2 weeks time is granted to do the needful.
Much obliged.
Yes, Mr. Mahesh.
Yes, my lord. Second respondent, my lord, unclaimed.
Yes.
Service may be held sufficient, my lord.
Good. Notice issued to respondent number 2, written with postal shara, but unclaimed. Yet service of notice to R2 is held sufficient.
Please.
For 10 days time.
Its time is granted to do the needful.
Much of.
Serial number 4, Irremated MR for appellant.
Yes, Mr. Viram. Permit counsel for appellant. Seeking dispensation of notice to R1 and R2. R1. Notice to R1 is dispensed. Once in notice kotilva. Process katail andre. You pay the process to respondent number 2. Yes, week's time is granted to pay the process to issue notice to respondent number 2.
Number 5, Shantaraj K for appellant. Kesava Prashant.
Yes, where is Kesha Prashant? Notice to R2 is dispensed. Delay of 82 days condoned next week.
Number 6, Sripad Shastri for appellant. AK Bhatt.
Yes, Mr. Notice to R1 is dispensed. Who is that?
My lord, my name may be deleted, my lord.
Which is?
6, serial number 6.
Yes, yes. Yaar bad. Wo Mahesh appeal hakidara. Yes. Office is Wo Mahesh is directed to take notice for respondent number 2. All this matter along with that so and so. Yes, office is directed to delete the name of Sripad V. Shastri for appellant. Yes, dispatch.
Number 7, Sripad Shastri for appellant. PB Raju.
My lord, I filed the dispensation memo and there is a delay. My
Yes.
lord, I am ready for disposal also. If PV
Yes,
Raju.
Mr. Raj. Yes, ready.
My lord, there is
Notice to R2 is dispensed. Delay of 378 days in filing an appeal is condoned, subject to not entitled for the interest. Yes,
it's a case of injury.
yes,
My lord, the date of accident is 14/2/2018.
yes,
He was aged at 30 years at the time of accident, working as a delivery boy.
yes,
Claims to be earning 13,000 plus 3,000 incentive, but it is not proved, man.
yes,
He sustained fracture of both the bones of right leg.
yes,
Treated as inpatient for 4 days, and external fixator was done. My lord, I have examined the doctor, my lord, PW2. My
Yes.
my lord, still there is a non-union due to which there is a 65% of limb disability resulted in 22% whole body disability.
What is that limb disability? 60?
65%.
Yes.
Well, compensation awarded is 1,90,000 medical
So
expenses.
what is the disability assessed by the tribunal?
Tribunal is only 18% and 9,000 is considered. Extent is of the year 2018.
Yes.
18 multiplied adopted. First point is loss of parents suffering 50,000 kottidare seems to be just and reasonable.
Yes.
Amenities kottilla. Loss
Yes.
of amenities, no compensation is awarded.
Yes.
And medical and incidental seems to be correct. Loss of earning, only 15,000 awarded. The evidence on the record shows for a long period he was hospitalized, bedridden and not able to attend his avocation. That is why 15,000 seems to be a lower side. And
Yes.
considering the year of accident, it's a 2018 accident. As per this chart, as per chart, it is 12,500.
Yes, yes, we'll consider. Yes.
In future loss also, a little bit lower side as far as the disability is concerned. So, 22%, it seems just and reasonable.
Yes, we'll consider it.
Yes.
Disability will consider 22%. Doctor said 22%. It is 65% is limb disability. 22 correct aguttali. Yes. 2% it will not make any difference. Yes. 3. Shastri, learned counsel appearing for the claimant has contended that due to that extent, claimant has suffered grievous injury. It was inpatient for a period of 4 days.
If my lord permits, I will go to other court.
Yes, yes, yes.
But I will come back.
Yes, yes. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered 65% disability to lower limb and 22% to whole body. Tribunal has assessed whole body disabilities, 18% is on lower side. Secondly, he has contended that at the time of the accident, claimant was earning 13,000 per month. Tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. Lastly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri P.B. Raju, learned counsel appearing for insurance company has contended that even though the doctor has deposed that the claimant has suffered 22% whole body disability, considering that evidence of doctor and injury suffered by the claimant, and considering that age and avocation of the claimant, the tribunal has justified in assessing whole body disabilities 18%. He further contended that even though claimant has claimed that he was earning 13,000 per month, he has not produced any document to establish the same. Under the circumstances, the tribunal has rightly assessed the monthly income of the claimant as 9,000 per month. Lastly, he has contended that considering that injury suffered by the claimant and considering that wound certificate exhibit P7 and discharge summary exhibit P8, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 14/2/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA 41 EE 3323. Due to the accident, the claimant has suffered the following injury. He has examined Dr. Krishna Prasad as PW2. In his evidence, he has deposed that the claimant has suffered 65% disability to particular limb, 22% whole body disability. Considering that evidence of doctor and considering that injury suffered by the claimant, I am of the opinion that the whole body disabilities can be assessed 22%. Even though claimant has claimed that he was earning 13,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2018, the notional income has to be considered as 12,500. At the time of the accident, he was aged about 25 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. 22%, 5,94,000. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined the claimant is entitled for loss of earning during the later period for 3 months, and he is also entitled for loss of immunities 40,000. Compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in court.
Sorry, my lord. Idu future prospects add ಮಾಡಬೇಕಾಗ್ತದ 22%.
You have not argued.
I brought it to the notice of the court, but
Yes.
that
You have not argued now. Now you are telling that. Yes.
that is is aged only a very young age, my lord. That is to be added, my lord.
No, that now I have to secure the record, sister. It is not on the basis. What is the injury? How it will affect your vacation?
How much?
Is there
How much? My lord, answer that. May I know? How much total?
Mr. Shastri,
Yes, my lord.
you
I'm
are all practicing in the bar so many years.
sorry, my lord. Sorry, my lord.
You are raising the ground. Can I consider that?
No,
You have not argued anything.
Sorry, my lord. Sorry.
Yes, Mr. No, it is not that. If you have raised that contention, I could have asked for the records. And he has also not argued because you have not argued. Then I have considered that case. Yes. Yes, in view of order dated so and so, the claimant is not entitled for the interest for a period of so and so days. Yes.
Siddaramaiah.
Yes. 2 weeks time is granted to do the needful.
Number 9 adjourned. Serial number 10 R. Lakshmana for appellant. G. Ramakrishna.
Yes. Where is Lakshman? Notice to R3 and R4 is dispensed. Delay of 83 days condoned. Is there any dispute regarding that income? Can be disposed of? Yes. Next. Yes.
Serial number 11 adjourned. Serial number 12 Vivek Kumar T for appellant. Lakshmi Narayan C.
Take mark. Notice to R2 is dispensed. Ready? Who is Vijay Kumar? So Lakshman
Narayan C. Lakshmi Narayan C.
next week.
Serial number 30.
Huh? Yes, Bharat next week. Yes.
Serial number 30 KV Nayak for appellant. United India Insurance.
United India Insurance Company are there. Notice to R1 is dispensed. R2 served unrepresented. Ruchubendra is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Office is directed to delete the name of Manjunath NT for appellant.
Number 14 adjourned. Serial number 50, R. Shashidhara for appellant, B. Pradeep.
Ready? Yeah. Notice to R1 is dispensed. Office is directed to secure original records from the tribunal.
Serial number 60, Pawan Chandra Shetty H for appellant.
R1 notice to R1 is dispensed. Yes. Which national? You will take, yes. TB Raju is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies. The request refer the matter to local.
Number 70, Narasimha Murthy GV for appellant, National Insurance.
Yes, wait. Who is there for National Insurance Company? Yes. Notice to R1 is dispensed. Delay of 679 days in filing an appeal is condoned. The appellant is not entitled for the interest. R2 served unrepresented. Party is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. You serve a copy. Yes.
Serial number 18, Shantaraj K for appellant, Reliance General.
Reliance General, who is there? But you are there. Yes. Notice to R1 is dispensed. R2 served unrepresented. Party is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. You serve a copy to party. Yes. Office is directed to secure records from the tribunal. Yes.
Serial number 19, Nayak Krishna for appellant, Reliance General Insurance.
Reliance, who is there? Party, you are there? Yes. Notice to R1 is dispensed. R2 is dispensed. R1 is served unrepresented. Party is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies.
Serial number 20, Pawan Chandra
Yes, Apodi or copy.
Shetty H for appellant, United India.
United India. You are there, Mr. Raja, United India. Yes. Notice to R1 is dispensed. R2 is served unrepresented. TB Raju is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Are you going copy code? Or the request refer the matter to local.
Number 21, Putteswamy for appellant, United India.
United India, you are there? Yes. Notice to R1 is dispensed. 1 or 2 days delay in filing an appeal is condoned. R2 is served unrepresented. Rushubendra is directed to take notice. Directed to serve one set of copies.
Number 22, Arjan. Number 23, Sanat Kumar KM for appellant.
Now, first time you have paid the process. Yes. Notice to R1 is dispensed. Who is there for Bajaj? Yes. D. Pradeep is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies.
Number 24, Nayak Krishna for appellant, Mohan Kumar T.
Yes, Mohan Kumar.
I prefer the respondent.
ready.
Insurance company's appeal is also there. I have
You have
also
filed
filed
an appeal.
Yes, the appeal is there.
Yes.
Maybe
Notice
posted
to
along with
dispensed. Call this matter along with
4965 of 21.
ನೀವು ಯಾವ್ದು ಬೇರೆ ಹೇಳ್ತೀರಾ ಅವ್ರು ಯಾವ್ದು ಬೇರೆ ಹೇಳ್ತೀರಾ?
I'm sorry, madam. That is FR number. This is 3411. 3411.
We'll give that number. Yes.
3411 of 2021.
Yes. Office is directed to secure original records from the tribunal.
Number 25, Gopal Krishna N for appellant, United India.
United India, you are there, Vinny. Yes. Notice to R1 is dispensed. R2 served unrepresented. Vinny is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies.
Number 26, Mohan Kumar T for appellant, Negative JPP.
I pay for the appellant, my lord. It's an insurance company appeal.
Yes.
My lord, so initially only the notice was ordered.
Read with objection is stays granted depositing before the. Yes,
Hello,
you are
then.
ready, Mr. Mohan Kumar.
But LCR baby contributory contributory negligence.
No, it is only, no, it is, you are challenging only that quantum.
Yes, quantum mene quantum nalle contributory ತಗೊಂಡಿದ್ದೀನಿ negligence ground ತಗೊಂಡಿದ್ದೀನಿ contributory negligence.
But then he has taken that the negligence is also, then records necessary. It is directed to secure original records from the criminal.
Your stay may be granted, my lord. I will deposit 50% of the amount.
ಸರ್ ಲೈವ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ವಿಶಾಲ್ ಪ್ರಸಾದ್?
Well, 50% award. I'll deposit 50%, my lord. Kindly grant
No,
stay.
no, that on what ground you are challenging, Mr.
My lord, I'm challenging on the ground of contributory negligence, and also, my lord, the claimants are majors. My lord, father, brother, and son, and major son, and major daughter. My lord, loss of estate ತಗೋಬೇಕು. They have taken, my lord, my lord, future loss of income. My lord, interest is also on the higher side. Well, 9% interest has been awarded. My lord, the daughter, the deceased was a pillion rider. So she went to highway, so without helmet and no DL, and she dashed against the car. My lord, therefore, my lord, I have taken the plea of, my lord, contributed negligence.
No, appeal is admitted.
Admit ಆಗಿದೆ. Admit ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I'm sorry that ಆ time I was not present actually on that day. So therefore, my lord, the court was pleased to, my lord, admit the matter, and LCL, TCL is also called for. Notice already admitted, but stay was not granted.
They have not yet deposited that amount. You have filed an application for withdrawing.
I presume that they have filed this application. The stay itself is not granted, and
Yes. Our stay of judgment and award dated 18th August 2021 passed by MEACT. ಎಲ್ಲಿದೆ ಇದು? ಹಾಸನ್,
ಚನ್ನರಾಯಪಟ್ಟಣ, senior civil judge.
ಚನ್ನರಾಯಪಟ್ಟಣ. In MEAC 959 of 2020, subject to deposit of 50% of the award amount with interest. Yes. Who are the claimants?
Husband, my deceased husband, and a major son, and major.
What is that apportionment, Mr.? Petitioner, first petitioner is entitled for the 50%. 2 and 3 are entitled 25% each. 2 and 3 are the majors.
Majors.
Now they fill in affidavit. Who has filed this affidavit, Mr.? Then we'll permit into Krishna Gowda share only. Yes. That first claimant has filed an IA for withdrawing that amount.
ಅಲ್ಲ, ಈಗ ನಾನು ಇನ್ನೂ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ, ಆಲ್ರೆಡಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
It's better, Mr. After that only. Otherwise, if they are not deposited,
Yes. I finally let them consider this application.
within 2 weeks. Yes. Then you will consider your application.
4 weeks. 4 weeks.
Yes, within 4 weeks. Yes.
Please.
ಸೀತಾರಾಮರಾವ್.
Yes. Accepting statutory deposit of rupees 3,500, which is excess of rupees 1,000. Yes. It's a amount deposit money. Yes. The statutory deposit made by the appellant is directed to be accepted. Third, issue notice. They are judgment and award dated 8th August 2022, passed by MEACT Changiri in MEAC 398 of 2019. All this matter along with that. Is there any? Yes. Now, what is that award amount? 5,000. Then you are already deposited by that. Yes. Yes, Mr. Mohan Kumar. Where is that main appeal? Yes. All this matter along with that MFA 5667 of 2019. Adರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ? ಉಮೇಶ್ ಅವರು ಇದ್ದಾರಾ? Yes, issue notice. Umesh, BS Umesh ala. BS Umesh is directed to take notice for respondent number 3. Issue emergent notice to 1 and 2. All this matter along with the MFA 5667 of 2019.
We have four for class objector.
Adhe matter? Yes. Umesh is directed to take notice. Issue emergent notice to 1 and 2. All this matter along with the phone. Yes.
Any interrogatory application matter, serial number 30, Shantaraj K for appellant, B Pradeep.
Yes, yes. Ready, Mr. Pradeep. Age is 24 years. Where is that discussion?
Yes, yes.
No, where is that discussion regarding the tribunal in that? Para 22.
Write on copy application.
Principal hand, since this is the age about 20 years applying the ಎಷ್ಟು ಇನ್ಕಮ್ ನೀವು ಕ್ಲೈಮ್ ಮಾಡಿದ್ದು 2015 1/3 ಕರೆಕ್ಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರಾ? Who are the claimants? Parents. Why the tribunal said 1/3? Yes. 1/4. What about that age? Now, what is that? Any other records you have produced? Aadhaar card yarದದು? Exhibit P9. ಎರಡಿದೆಯಲ್ಲ exhibit P13. $27. Yes, that's all. What is that interest, Mr.? 7%. Yes. Sri Shantraj, Learned Council appearing for the claimant has contended that at the time of the accident, deceased was earning 15,000 per month. Tribunal has considered the notional income of the deceased as 6,000 per month is on lower side. Future prospects kotidara. He further contended that there are 4 claimants. They are entirely depending upon the income of the deceased. The tribunal, instead of deducting 1/4 of the income of the deceased for personal expenses, error in deducting only 1/3. Lastly, he has contended that in view of judgment of apex court in case of Megma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, B. Pradeep, Learned Council appearing for insurance company, has contended that even though the claimant has claimed that deceased was earning 15,000 per month, They have not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the deceased as 6,000 per month. He further contended that, considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal, 7%, is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute. What is the name of the deceased? Selvam died in road traffic accident occurred on 16/3/2015 due to rash and negligent driving of rider of motorcycle bearing registration number KA 42 R 8899. Even though claimants have claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2015, the notional income has to be considered as 9,000. There are 4 dependents. Hence, 1/4 of the income of the deceased has to be deducted for personal expenses. The tribunal has rightly added 40% of the income of the deceased as future prospects. At the time of the accident, deceased was aged about 27 years. The multiplier applicable to that age group is 17. Accordingly, loss of dependency has been reassessed as follows.
1,600 minus 3,150 at the rate of 1/4, 9,450, 9,450 into 12 into 17, 19 lakhs 27,800.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, first claimant is entitled 44,000 for spousal consortium. Claimant number 2 is entitled 44,000 for parental consortium. 3 and 4 is entitled 44,000 each for filial consortium. The medical expenses awarded by the tribunal is retained. The enhanced compensation amount carries 6% interest. 11. Yes, not entitled for the interest for a period of 224 days.
Number 31, yes, Krishna Kishore.
Yes, Suresh. 78 days delay in filing an appeal is condoned. IA 1 of 2019 is allowed. What is this, Mr.? Is there any dispute? Where is Krishna Kishore? Any liability dispute is there? You're not aware? Yes.
Number 32, Sanat Kumar again, Mohan BK, Muralidhar Megawat.
Yes. Mohan BK. Who is appearing for insurance company?
Muralidhar Megawat.
Yes, second respondent. Muralidhar. Password.
Number 33, DS for appellant, Sohani S. Walla.
Ready, madam? Yes. Records necessary. Yes, Mr. Rashid. Is there any dispute regarding that? He is not. No, regarding what? No, liability, you are not filed any. Are you challenging any liability? You are not filed any appeal. No, quantum, he is not disputing that disability. Let us see if it is required, I will. What is this case? Yes, Mr. What is the disability assessed by the doctor? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು? ಅಷ್ಟೇ. Yes, madam. Then why do you want records? Yes. Yes. He is not pressing all this. You just answer what he is raising only. Huh? No, now he is saying only for the pain and suffering and loss of amenities. For that, what is your this thing? No, pain and suffering, what are the injuries he has suffered? Yes, letter, huh? What is that injuries? Yes. Yes, there is a one severe injury. Yes, then pain and suffering that awarded has to be enhanced to 20,000 to 40,000. Then amenities another 20,000, 40,000. 40,000 we can enhance. Yes, madam. Yes, I will consider your service. See the learned council appearing for the climate delay of 225 days is controlled not entitled for the interest. So and so contended that due to the extent the claimant has suffered grievous injury. He was inpatient for a period of she was inpatient. She was inpatient for a period of 1 day. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lawyer side. Hence, he sought for enhancement of compensation. For contra, so learned counsel appearing for insurance company has contended that the injuries suffered by the claimants are minor. BMTC, yes, appearing for the corporation has contended that the injuries suffered by the claimants are minor in nature. She was inpatient only for 1 day. Yes, 1 day. Considering that evidence of doctor and injuries suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, and other incidental expenses is just and reasonable. Lastly, she has contended that the interest awarded by the tribunal, 8% is on her side. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 9/5/2017 due to rash and negligent driving of driver of bus bearing registration number AA 57 F1431. Due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 20,000 to 40,000, 20,000 to 50,000, and loss of immunities from 20,000 to 40,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest. The claimant is not entitled for the interest for enhanced compensation amount for a period of 225 days. Yes, where is Keshav Prashant? Have they filed an objection? none appear for the respondent. As a last chance, release this matter next week.
Number 35, Abhijit MM for appellant. S.B. Srikanth.
Your Lordship,
Yes.
appearing for the respondent in this case.
Yes.
Your Lordship, due to some personal emergency, my senior is unable to appear for the matter today. So kindly have it next week.
What you say about that delay, madam? Have you filed any objection?
Uh,
No, you are appearing for whom? Your appellant. She has to file an objection, not you. Yes.
yes, sir. Yes.
Have
sir.
they filed? Yes, madam. What you want?
Your Lordship, I'll be filing the objections by next week.
Yes. Which is that connected, madam? No, that connected means what? Arising out of the same accident. Yes. Senate Council for appellant submits that. Appeal may be, this matter may be called along with the so and so.
Number 36, adjourned. Bill number 37.
Much obliged, Your Lordship.
Appellant, P.S. Mustafa.
Hmm. Hmm. Hmm.
They have not, wife and the children have not.
Hmm.
They have not been attending that issue.
Hmm. Hmm.
Meanwhile, there was an original filed by them also, which is pending before the court.
Hmm.
They have not. In this petition, other place expired. Other family members of the first wife
Hmm.
and the children of their place expired. And the judgment will pass. Appeared. The insurance company have no record. But other, there is a question of the question is not explained right. This compensation. Withdrawal of the compensation.
Now that see, definition of legal representative is different, is it not? It is not in a legal hair. They are depending upon that income they are living, that they have to be established.
They have not produced only one certificate of this affidavit. Nothing has been on the record that he is
Now then we have to see that evidence. Now that what is the finding of the tribunal?
awards a compensation also direct slave recovery.
Hmm.
And that doesn't go with the second wife of first wife because the first wife entire family was expired.
No, that is true. First wife they may not be interested, but that second wife, they, if it is legally depending upon the income of the deceased,
That is not.
where is that? Have you taken that contention? Why?
All of us are.
No, ex parte means served, you have not appeared. Then
That is but we are unable to find who has been served. So, because two litigations.
no, are you disputing that notice is not served to you? Then we'll secure the records. We'll see that how the.
And among the insurance company have responded,
Yes. Who is appearing for that claimants here? Yes. 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 They are not claiming. Yes. Heard. Issue notice. Heard on IA 2 of 2020. 20ರಿಂದ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಾವು how can you say that? Now let it be there. Why you want to stay? They have not. ಆಯ್ತ್ರಿ ಈ 2 ವರ್ಷದಿಂದ ದುಡ್ಡು ತಗೊಂಡಿಲ್ಲ ಈಗೇನ್ ತಗೊಳಕ್ ಯಾವ್ದೇ ಮೇಡ್ ಏನಿ ಅಟೆಂಪ್ಟ್ have they filed an execution ಮಾಡಿದ್ದಾರೆ yes yes heard on IA 2 of 2020 stay of disbursement of amount deposited by insurance company before the tribunal as per the judgment and award dated 27th July 2019 for a period of 4 weeks. Office is directed to secure original records from the tribunal. Connected matter another. They have filed. Yes, call this matter along with the sounds.
R. Shashidhara for appellant, P.P. Raju.
Yes, ready. Ready, Raju. Yes. Two 2017. Yes. 60. Yes. What was his income? ಎಷ್ಟಾಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು 7.5. ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಏನಿಲ್ಲ. Yes, cross 60 ಅಲ್ಲ. Yes. Then what is the deduction, Mr.? 150. Yes. There is no dispute that. Then other head. What is the interest? 9%. That's all. That will consider. Yes. As per the Supreme Court judgment. Yes, Sri Shashidhar or learned counsel appearing for the claimant has contended that at the time of the accident, deceased was earning 30,000 per month. Tribunal has considered the notional income of the deceased as 7,500 per month is on lower side. Secondly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, the P.B. Raju learned counsel appearing for insurance company has contended that even though the claimant has claimed that deceased was earning 30,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly considered the notional income of the deceased as 7,500. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal 9% is on higher side. And he further contended that, secondly, he has contended that considering that age and avocation of the deceased and also the claimants are major sons, considering the same, the tribunal is justifying awarding the compensation. The compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. What is the name of the deceased, Mr. Papaya? Papaya died in road traffic accident occurred on 22/8/2017 due to rash and negligent driving of driver of lorry bearing registration number KA06C2691. Even though the claimant has claimed that deceased was earning 30,000 per month, they have not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2017, notional income has to be considered as 11,000. The tribunal has rightly deducted 1/5 of the income of the deceased for personal expenses. At the time of the accident, he was aged about 60 years. The multiplier applicable to that age group is 9. Accordingly, loss of dependency has been reassessed as follows.
7,000 minus 2,200 at the rate of 1/5, 8,800, 8,800 into 12 into 9 lakhs 50,400.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, who is first claimant, wife? First claimant is entitled 44,000 for spousal consortium. Second, third, third. All children. The claimants number 2 to 7 are entitled 44,000 each for parental consortium. Finance compensation amount carries 6% interest. No, division bench said they are entitled only 6%. Therefore, when I am enhancing, I have to say 6%. Since they have not challenged, I have not said that 6% in respect of the award amount by the tribunal. Only that enhancement, there is a 6%. If they have filed, I say that 6% from the date of accident.
I, Krishna for appellant, V. Subhash Reddy, V.S. Krishna, United India.
Yes. That claimant's appeal. Now that you are appearing for whom? R2 United India. R3. Why? United, yes. P.S. Krishna is directed to take notice for respondent number 3. Ready? Ready, madam? Why? What you say about the delay? Have you filed an objection for delay? Have they filed? You are not. What you want now today? Yes, they want. The request of counsel for respondent number 2. Release this matter next week.
Party Spurti Agreement for appellant, B. Chivanya Gowda. Serial number party.
Spurti Agreement. Ready? There is Chivanya Gowda. Pass out. Pass out. Huh? Kya bandila? Will condone the delay. Delay of 224 days condoned, not entitled for the interest.
Spurti Agreement for appellant, S.N. Keshav Prashant, B. Pradeep.
Office is directed to delete the name of B. Pradeep. Pass out. Really? 40-41 same. Then why that 2 different councils have appeared for insurance? Office is directed to delete the name of B. Pradeep for respondent. 224 days delay condoned, not entitled for the interest. All this matter along with that 40.
Number 42, N. Krishna for appellant.
Yes.
Serial number 42. Matter. Serial number 43, 44 Arjun, serial number 45, Ravishankar CR for appellant, N. Gopala Krishna.
Sorry.
Serial number 46 Arjun, serial number 47, Gopal Krishna N for appellant.
46, Ravi Samprati wants time to file an wakalat. Next week. Next week, Ravi Samprati has taken time. Yes. 47S. Who is appearing for other side? Pass over.
Number 48, B. Pradeep for appellant, B. Sitaramaya.
Yes. At the request of counsel for parties, release this matter next week.
Number 49, Adjan. Number 50, Suresh M. Lathur for appellant, B. Pradeep.
Suresh M. Lathur. Pass over.
Number 51, Ashok Kumar, 50K for appellant, B. Sivanya Ruda.
Pass over.
Number 52, Antaraj K for appellant, yes, Nirmala.
Yes, ready, madam. Yes. Yes. Aggression over the right neck, severing pain at tender present middle of the right. Yes. Yes, point is there a disability? What is that? Yes. What is that income, Mr. Sankar? 2017, na? Pain and suffering. Yes. Medical expenses, food and nourishment, transportation costs, loss of amenities. Opinion service, loss of income, loss of income. Yes, madam. Yes. Yes, that's all. Three. Chantraj, Internet Council appearing for claimant has contended that at the time of the accident, claimant was earning 15,000 per month. Tribunal has considered the notional income of the claimant as 8,000 per month is on lower side. Further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, yes, Nirmala, Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 8,000 per month. If he further contended that, considering that evidence of doctor injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 12/4/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA06 EK 2783. Due to the accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017, the notional income has to be considered as 11,000. At the time of the accident, he was aged about 28 years. The multiplier applicable to that age group is 15. Forty years tandidara. Yes, he was aged about 40 years. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000. Loss of immunities from 15,000 to 40,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal, in the other hand, are just and reasonable. Yeah, it is condoned. There is no interest as denied.
For appellant, B. Pradeep.
Yes, Satish PCR Kaputila, owner of the vehicle. Who is appearing for the owner? Alla tribunal alla our mele madidare. Our challenge madilla. If it is you have to give a finding, then he has to be heard. If it is finding has been given but he has not challenged, then if he has not appeared, then he has accepted. Nodi avrudana appeal ide. Why that liability on the owner? Then pay and recovery. Then it will be helpful for him. Yes, Mr. What is the case? Yes. 2013. How many days in that hospital? What is that income? 10,000. Tribunal ಎಷ್ಟಾಂಡಿದ್ದಾರೆ 13 ಗೆ 8 ಕರೆಕ್ಟ್ ಇದೆ. Disability ತಾಂಡಿದ್ದಾರೆ. Income ಅದು ಇಲ್ಲ. Only that liability and other head. Where is that discussion regarding that liability? Yes. Read, Mr. Yes. Yes. Appeal ಇದೆಯಾ? How many injuries, Mr. Where is that injury? What are the major injuries, Mr. Pradeep? Two injuries. It is loss of future earning, nourishment, loss of income during the later period. ಕೊಟ್ಟಿಲ್ವಾ? Nourishment diet to 10,000 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. Yes, you are only 12 days. Yes. Yes. See, Satish, a council appearing for insurance company, the climate has contended that due to that accident, the climate has suffered grievous injury. He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of income during the later period. Hence, he sought for enhancement of compensation. For contra, Sri B. Pradeep Learned Council appearing for the insurance company has contended. Secondly, he has contended that the tribunal, even though tribunal has held that insured has violated the policy condition, insurance company is not liable to pay the compensation. But in respect of claimants is concerned, insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. In support of this contention, he has relied on judgment of apex court in case of Rani. B. Pradeep, Learned Council appearing for the insurance company has contended that considering that evidence of doctor injury suffered by the claimant, the compensation awarded by the tribunal, the pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal is 9% is on higher side. In respect of liabilities, he contended that at the time of the accident, the offending vehicle was not having valid permit. Since insured has violated the policy condition, the insurance company is not liable to pay any compensation. Therefore, tribunal has rightly exonerated that insurance company from the liability. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, arose judgment and award. It is not in dispute The claimant has suffered an injury in a road traffic accident occurred on 10/1/2013 due to rash and negligent driving of driver of lorry bearing registration number TN72 R3422. Due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000, loss of immunities from 30,000 to 40,000. The claimant is entitled loss of income during the later period for 3 months. The enhanced compensation, the compensation awarded by the tribunal in the other hand, are just and reasonable. The enhanced compensation amount carries 6% interest. In respect of liability, the tribunal, after considering that the evidence of the parties, has held that the offending lorry had no permit to fly within the state of Karnataka, and rightly held that the insurance company is not liable to pay that compensation. In view of judgment of apex court in case of Rani, in respect of claimant is concerned, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit the compensation amount with interest within 6 weeks from date of issue of a copy of this order, with liberty to recover from owner of the offending vehicle. In view of order dated 15/7/2022, claimant is not entitled for the interest for a period of 197 days.
Number 55, please proceed for appellant Nagaraja Hegde, connected matter, universal shampoo.
Now that universal shampoo, who is appearing? Even you are taking notice in that. Ready? Yes. Why? Where is that discussion? Two to five. Andre 2, 3, 4, 5. 3 injuries. Major. Yes. Yes. 2 are minus, 3 are major. Yes. ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್? ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರು? 24 days. $300 per day ಮಾಡಿ towards loss of earning during the later period. 7,200 monthly ಎಷ್ಟು ಇನ್ಕಮ್ ಮಾಡಿದ್ದಾರೆ? 9,000. 1 lakh loss of earning during the later 15 months. Why the 15 months? Because that at the time of discharge, the petitioner was advised to complete bed rest for a period of 15 months. Doctor has said 15 months. There is an advice from the doctor. What is evidence, doctor? Say that it was admitted so and so, with complete rest of 15. What is the cross examination regarding that? ತಾತ್ಕಾಲಿಕವಾಗಿ ಯಾವುದೇ ಬರವಣಿಗೆಗಳು ಪ್ರತಿರೋಧದ ಗಾಯಾಳು ನಾನು ಹೇಳುವಂತೆ ಅಂಗನ್ಯೂನ್ಯತೆ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗಾಯಾಳಿಗೆ 15 ತಿಂಗಳು ಕಾಲ ಪೂರ್ವ ವಿಶ್ರಾಂತಿ ಬೇಕಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಗಾಯಾಳಿಗೆ 6 ಇಂಚಿನಷ್ಟು ಮೂಳೆ ನಷ್ಟವಾಗಿರ್ತದೆ. Deny ಮಾಡಿ then he has given an explanation why that yes, only the 2 grounds. Tribunal ಎಷ್ಟು ತಾಂಡಿದ್ದಾರೆ? 40 ತಾಂಡಿದ್ದಾರೆ. 47 ಇದೆ ಅಂತನಾ? What are the documents he has produced? Aadhaar card is the genuine document. Yes. Next is that age. Bedrest, amenities ಕೊಟ್ಟಿದ್ದಾರೆ, nourishment, attendance charges ಎಲ್ಲ ಸೆಪರೇಟ್. ಇನ್ಕಮ್ ಎಷ್ಟಿದೆ ಇದು? ಅಲ್ಲ, ಯಾವ್ದು ಆಕ್ಸಿಡೆಂಟ್? 2018 ಎಷ್ಟು ತಾಂಡಿದ್ದಾರೆ? 9,000 12,000 ತಾಂಡ್ಬೇಕು. 2,500 roughly 120. You know, he was working. Where that employer? What is that income he has claimed? P10. So why the tribunal has disbelieved that? Yes, Mr. Then you have continued in that service. Last week. Yes. No, 3 years grievous. That is what that 2 to 5 are grievous. 2 to 5 are grievous ಅಂತಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? Where is that? No, where is the doctor said? Fracture of public grievous. 1, 2, 3, 4 grievous. 5 grievous. 5 grievous. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ವೆರಿ ದಟ್ ಇಸ್ they are admitted to so and so disabilities, permanent physical disability of 40% to right lower limb. As for the doctor itself is 40%. 20% ತಾಂಡಿದೆ ಅಲ್ಲ ಡಾಕ್ಟರ್ಗಿಂತ ನಾವೇನ್ ಎಕ್ಸ್ಪರ್ಟ್ ಅಲ್ಲ ನಿಮ್ ಡಾಕ್ಟರ್ he said I can't say doctor said is not correct, then I should be expert. Doctors ಏನ್ ಹೇಳಿದ್ರು ಅದನ್ನ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ then will consider this is our part. We cannot be you take into that doctor evidence itself, it is sufficient to what they said. Maybe. Why? Where is that evidence of the doctor? She can't do any this thing. Yes. 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 Padmavati assistant. Due to the said difficulties, problem of the petitioner has permanent physical disability of 40% to right lower limb. He has not said because of this disability he can't do any work. Need help of walking, aid of the minimum walking, and she has got a difficulties to do the self-help activities. Physical disability and difficulties, petitioner could not able to do that work of the cooling or any other kind of the labor activities. Yes, what is that class examination? Yes, yes, Mr. Doctor has said she can't do that work of the coolie or any other kinds of the labor activities. ಅದು 100% ಅಂತ ಏನೋ ಬರ್ದಾರೆ ಆಮೇಲೆ ಮತ್ತೆ ಹೊಡೆದಾಕಿದ್ದಾರೆ. Yes. Yes. Yes, that's all. B. Pradeep, Learned Council appearing for ಅದರಲ್ಲಿ ಎರಡನೇ ಮ್ಯಾಟರ್ B. Pradeep, respondent number 2, third unrepresented B. Pradeep is directed to take notice. Delay 175 days, control not entitled for the interest. B. Pradeep, Learned Council appearing for the insurance company has contended that even though claimant has claimed that he was earning 18,000 per month, she was earning 18,000 per month. She has not produced any document to establish the same. Therefore, the monthly income assessed by the tribunal 9,000 9,000 per month is on higher side. He further contended that as per the evidence of the doctor, the claimant has suffered 40% disability to right lower limb. Tribunal has assessed whole body disabilities 20% is on higher side. The claimant is also not entitled for any future prospects since she can able to do her day-to-day work. The limb disability is only to that extent of right lower limb. He further contended that injuries suffered by the claimants as per that material available on records is three major injuries and 2 minor injuries. The compensation awarded by the tribunal for pain and suffering 1,30,000 rupees on a higher side. He would further contended that the injuries suffered by the claimants are minor in nature. She was inpatient only for a period of 24 days. The compensation awarded by the tribunal for bed rest for loss of income during the later period 1,08,000 is on higher side. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for loss of immunities, other incidental expenses is on higher side. When she sought for reduction of compensation. For contra, Sri Hegde, learned counsel appearing for the claimant has contended that due to that extent, the claimant has suffered 5 grievous injuries, 2 minor injuries as per the evidence of doctor. He further contended that doctor has assessed the physical disability of 40% to right lower limb. Due to the disability, she is unable to do her day-to-day work and she has not continued her employment. Therefore, the tribunal has failed to assess the functional disability and tribunal has not granted any compensation under future prospects. In support of his contention, he has relied on judgment of apex court of future prospects. Secondly, he has contended that at the time of the accident, the claimant was earning 18,000 per month. She has produced salary certificate. Has produced salary certificate as exhibit P10. The tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. She was inpatient for a period of 24 days. She has suffered a lot of pain during the treatment. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Heard the learned counsel for the parties, Perros, judgment and award. It is not in dispute. The claimant has suffered an injury. Road traffic accident occurred on 5/2/2018 due to rash and negligent driving of driver of car bearing registration number AA20 MB 3021. Due to that accident, the claimant has suffered the following injury. She has examined Dr. Dinesh Kumar Shetty as PW2. In his evidence, he has deposed that the claimant has suffered 40% disability to right lower limb. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has justified assessing the whole body disabilities 20%. Due to the permanent physical disability of 40% to the right lower limb, as per the evidence of the doctor, she was unable to do the work of coolie or any other kind of labor activities. Considering that evidence of doctor and injury suffered by the claimant, and in view of judgment of apex court in case of so and so, I am of the opinion that the claimant is entitled for future prospects. Even though claimant has claimed that she was earning 18,000 per month, she has not produced any document to establish the same. She has produced salary certificate, but she has not examined that employer to prove the same. Under that circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income has to be considered as 12,500. 12,500. In view of judgment of apex court in case of Pranay Sethi, what is her age? 25% of the income of the deceased has to be added for future prospects. The multiplier applicable to the age group is just 15. Accordingly, loss of future earning has been reassessed as follows.
The rate of 25%, 15,625, 15,625 into 12 into 15 into 20%, 5,62,500.
Due to that extent, the claimant has suffered 5 grievous injury as per the evidence of doctor and 2 simple injuries. Considering that evidence of doctor and considering that wound certificate, that a compensation for pain and suffering has to be awarded for 85,000 instead of 1,30,000 awarded by the tribunal. For loss of immunities, the compensation awarded by the tribunal is just and reasonable. In respect of loss of income during the later period, considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the claimant is entitled loss of income during that later period for 8 months. 8 months and rest, I think 12 2,500 into 8 months. Huh? 1 lakh. Yes, has to be reduced from 1,08,000 to 1 lakh. The compensation awarded by the tribunal, in the other hand, are just and reasonable. Accordingly, the appeals are allowed in part. Appeals are disposed of. Judgment and award passed by the tribunal as modified as follows. Amount in deposit. The claimant is not entitled for compensation of rupees 7,200 for loss of earning during the treatment. Amount in deposit is transferred to the tribunal. Interest in view of order dated so and so, the claimant is not entitled for the interest for a period of 175 days.
GR Venkatesh.
ಅಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ then matter has to be onerous out as heard. Pass over. Yes, Mr. Yes, Mr. Keshav Prashant.
That a short accommodation may be given, my lord. Negligence and a quantum is questioned. I'll argue the matter in the next week, my lord.
Yes, heard. Where is your appeal? Yes, call this matter along with that so and so. Yes, their appeal is also there.
Agboth, sir.
We are Dakar.
Yes. Yes. Yes, we'll call along with Learned Counsel for respondent number 2 submits that this appeal may be called along with the so and so. Yes, yes. They will.
Nayak Krishna for appellant. Radeshwari, Keshava Prashant.
They respond in this case. That may be
Yes,
taken
Mr.
up for disposal. I'm ready.
Yes, ready.
Death case. Only the
Yes.
thing is, Lord, quantum. He was a bachelor, 19 years. Tribunal has considered 7,000
Yes.
rupees.
Naik is here. Yes.
ಮುಗಿಸ್ಬಿಡ್ಬೋದು.
Yes, 2018.
ಹೌದು 12,500 plus 40%.
Yes.
50% deduction. Bachelor.
Keshav Prashant, he is here.
I'm sorry, my lord. I thought that, my lord. Yes.
Yes. ಅಲ್ಲಿ camera ಕಾಣಿಸುತ್ತಲ್ಲ. Yes, yes. Yes, Mr. Parents and ಎಲ್ಲಿದೆ ಬರೀ ಪೇರೆಂಟ್ಸ್? Father, who is that first petitioner? Mother, second is the sister. Yes. Father, why father is not joined with that mother? ಅದೇ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ. They are not I 20,000. What is that income taken by the tribunal? 7,000 ತಗೊಂಡಿದ್ದಾರಾ? 12,500. What is his age? 20 years. What is the deduction by the tribunal? 50% ಮಾಡಿದ್ರು. ಮಾಡಿದ್ದಾರೆ. Income has to be enhanced ಅಷ್ಟೇ. 40% ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. That will reassess. ಅಂದ್ರೆ 3 ಜನ ಇದಾರಲ್ಲ, 4 3 12.
150 ಆಗ್ಬೇಕು. 150 ಆಗ್ಬೇಕು.
ಎಸ್. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Funeral expenses. Yes, dependency. Three. Mike. Learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 20,000 per month. Tribunal has assessed the emotional income of the deceased as 7,000 per month is on lawyer side. Further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. Per contra, the Keshav Prashant, learned counsel appearing for insurance company, has contended that even though the claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the deceased as 7,000 per month. Further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has, what is the name of the deceased? Sarvana. Sarvana died in road traffic accident occurred on 26/6/2018 due to rash and negligent driving of driver of Tata Ultra vehicle bearing registration number KA53 C4883. Even though claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. Under those circumstances, the notional income must be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income must be considered as 12,500. The tribunal has rightly added 40% of the income of the deceased for future prospects. Since deceased was a bachelor, 50% of the income of the deceased has rightly been deducted for personal expenses. The multiplier applicable to the age group 19 is 18. Accordingly, loss of dependency has been reassessed as follows.
500 plus 5,000, the rate of 40%, 17,500 minus 8,750, at the rate of 50%, 750, 8,750 into 12 into 18 lakhs.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of the first claimant is entitled 40,000. First claimant number 1 and respondent number 3 before the tribunal are entitled 44,000 each for filial consortium. Claimant number 2 is entitled 44,000 for love and affection. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as well.
Not entitled for the interest delayed period.
Yes, not entitled for the interest. There is no any such this. As for that opposition.
Matter, cell number 60 adjourned, cell number 61, this is Sita Ramarao for appellant, Srikanth M.
Yes,
Madhavan Reddy.
Who is that other rest? Who is your opponent? ಇದೆಯಾ MFA crab? ಏನಾಗಿದೆ ಅದು? ಏನಾಗಿದೆ? What is that? Then how can that can be disposed of when your appeal is there? ENP. Then it will. Then there is no hurdles. You can argue on your matter. We'll have it next week. None appear for. If it is on the merit, then it cannot be. Yes. Who is that contesting respondent? Huh? Alala, yaar advocate yaar. None appear for respondent 1 and 2 as a last chance. Release this matter next week. Next week we'll dispose of this there now. None appear for 1 and 2 as a last chance.
Number 62, 63, 64, 65, number 66. O Mahesh for appellant, KT Gurudeva Prasad.
Yes, Mr. Mahesh. What is this, Mr. No, that how that accident has occurred?
Serial number 66. O Mahesh for appellant.
Factorization policy. Even trailer has hit. Trailer was not insured. Our division bench KL Manjunath ಕೊಂಡಿದ್ದಾರೆ. Since accident is occur, without that engine, it cannot be happen. Therefore, yes, Mahesh. Yeah, the new court is the judgment. Our Justice Mudgal. Factor not the trailer. Therefore, whether the trailer was registered or insured is irrelevant fact. Further submitted that insured is not technically of carrying water commercial purpose. Password. Mahesh is there, but he is on that other court on the council. 2:30 or next week. Yes. None appear for the appellant. Release this matter next week.
Janardhan Reddy for appellate, connected matter. PL Nanjunda Swami.
You are there, ready? Yes. What is this, Mr.? Hmm. 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 No, is it necessary? That is true, but just because there is no complaint and FIR, is the lady there? Witness examine so and so. The tribunal was error in holding that death as event occurred in the accident involved motive. Though the limit have to rely upon the evidence of the claimant in this regard, highlight the fact that death occurred in the accident involving the next step and careful perusal of the evidence of produced. I am of clear view that claimant failed to prove that death involved in the motorcycle. Regarding the funding, the absence of the complaint being lodged at the earliest point of the time. Complaint will be there and reject madbekantiಲ್ಲ, but they have to prove what is that tribunal has held, how it has been proved. He has stated that she has fell from the bike. Further, as per the principal ILR so and so, though the occurrence of the motor accident is not reported, tribunal due to the determining compensation number. Habitat fact. In the present case, particularly clearly stated that the owner of the vehicle is her husband and the rider of the vehicle was her husband's friend. Suppose that her husband and her husband's friends, both of them, asked her not to lodge any complaint. Complaint is lodged when the friends of her husband is friend. The version of the petitioner in the facts and circumstances of the case presentation, I think it is the case of believable as she stated before the doctor that she fell from the bike. Therefore, the defense taken by the insurance company that the accident is not at all caused due to the rash and negligence. ಏನಾರ ಐ ವಿಟ್ನೆಸ್ ಇದೆಯಾ? ಅಲ್ಲ, ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿಗೆ ಪಿಲಿಯನ್ ರೈಡರ್ಗೆ ಆಗುತ್ತೆ ಅನ್ನಂಗಿದ್ರೆ ಇಫ್ ಇಟ್ ಈಸ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್ ದೇ ಕ್ಯಾನ್. ಹಾ, ಬಟ್ ಅವ್ರ ಆಕ್ಸಿಡೆಂಟ್ ಹೆಂಗಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಲ್ಲ, ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ she was traveling as in a pillion rider, so also the rider was once incorrectly so the petitioner husband accident was due to that he was driving rash and negligence on the road and the petitioner sustained injury or leg which was fractured and the vehicle is also damaged. Who are that PW2 and 3? Doctor 3. Certificate, prescription, bill, discharge summary. Injuries, there is no dispute. And the point is that whether is there any negligence. ಅದೇ ಅವರೆಲ್ಲಿ ಇಲ್ಲಲ್ಲ. ಹೂ ಇಸ್ ಯುವರ್ ಅಪೋನೆಂಟ್? Hmm. 2013, as per the general order having been so and so 12 days in filing. Janardhan Reddy, ಯಾರದು ಕೌನ್ಸಿಲ್? ಯಾರು? ಹೂ ಇಸ್ ದಟ್ ಮೆನ್ಷನ್? ಪಾಸ್ ಔಟ್ ಮಾಡ್ತಾನ? Yes. None appear for respondent in appeal number 10320 of 2012 and appellant in MFA 640 of 2013 as a last chance. Release this matter next week. What do you order the last occasion? Request. ಎಲ್ಲೂ ಬಂದಿಲ್ಲ ಇದು 2014 ಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ? ನೋಡೋಣ ಒಂದು ಚಾನ್ಸ್.
ಶಿವಣ್ಣ for appellant, K. Ravishankar, Sri Mahadeva Swami.
What is this, Mr.? ಅಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? No, why the pain recovery? Yes, Mr. K.
It is within the band of stupidity. I have tried more than the 25 years. The accident was made. Therefore, there is a condition violation of the policy. Therefore, the condition is not taken into
No, but Supreme Court said violation of that route permit pain recovery. The Supreme Court judgment. Amrutpal and Rani case. Supreme Court said in that situation also pain recovery. That in case of Rani, the permit is there in that Andhra, he was playing in Karnataka. The Supreme Court said pain recovery. That is what we are consistently following in all cases. It is there in our High Court judgment, but Supreme Court said. Then nothing wrong in that pain recovery. Yes, then why that the insurance company is challenging now? That pain recovery, now that it is there and that then their appeal. ಅಲ್ಲಿಗೆ ಎರಡು ಅಪೀಲ್ ಹೋಗುತ್ತೆ. ಆ ಜಡ್ಜ್ಮೆಂಟ್ has to be confirmed. That's all. Yes. Because I am following that in consistently in all cases. Amrutpal and Rani. Then you will have 2:30. You just go through it. Yes, then. Yes, next week. Yes. See, he is not in a regular counsel in motor vehicles. Therefore, he is not aware. Yes. Then today afternoon he has some personal inconvenience. Otherwise, I could have. Yes. We'll have it on Monday, Tuesday. Yes, 16. Yes. Release this matter on 16. Yes, madam. What is this? Huh? Yes. No, you are appearing for the owner of the vehicle. What is about that other appeal? All ಅದು ಇನ್ನು ಬೇರೆ matter ಅಲ್ಲ? Why it is dismissed? Petitioner. No, how the accident was occurred, the manner of accident. Bypass road near so and so, Dharwad at about 8 p.m. The driver of the petitioner, Sri Nagaraj Ganapati Naik, was driven the said Tata Sumo bearing registration number belongs to the petitioner. Who was at Bangalore, you are driving said vehicle carefully, so and so they are returning from vehicle reached near so and so truck bearing. You are that owner of that Tata Sumo. That negligence is cast on the truck. Then why dismissed? Now that there is a judgment saying that they have to given a compensation for that first six. You are claiming for what about that injury? Nobody's suffered injury, only vehicle damage. So in that vehicle, when such being the case, it is crystal clear that petitioner violated the condition of the permit, probably by considering the same. Petitioner issued has declined to consider his claim. Since the petitioner violated the permit condition, it is probably that. Yes, you have violated the permit condition. No. See, negligence is entirely on that other vehicle. See, now you are claiming as in a third party or insurer of that other vehicle. No, that when they said they are negligent, then whether you are violated that condition is immaterial. Yes, who is appearing for other side? No, how is that material that, see, if you are claiming a compensation from your insurer, then they cannot do. But if you are violated, that is nothing to do with that. Where is that finding of the tribunal? Yes. Yes. No, pass over Srinivas, I think he will come. Let us see. Just you try. If it is afternoon, I don't have any other one. If it comes, we will discuss. It's an old matter. No, you just see. He has to answer. I don't think any further. If it is necessary, I will grant time. Yes.
Number 17, A. Hanumantaraya for appellant, Sabiti Sitaram Rao.
Yes, what is this, Mr. Yes. Proceed, please. As it for respondent number 2 appear through video, that last occasion you have taken time. It is a possibilities. Yes, none appear for the appellant. At a last chance, release this matter of 2 weeks. Otherwise, we will discuss.
Matters list number 2, serial number 32, Sanat Kumar came for appellant. Mohan B.K. Muralidhar Megawatt.
Muralidhar. Pass or inform 230. 230, madam.
Serial number 42, A.N. Krishnaswamy for appellant.
Pass out.
Number 45, Ravi Shankar C.R. for appellant. N. Gopala Krishna.
Where is Ravi Shankar? Hotel Madhyana Karkabani. Pass out.
Number 47, Gopala Krishna for appellant. S. Surya Narendra.
Adu avre.
Number 50, Suresh M. Lathwar for appellant. V. Pradeep.
Pass out.
51, Ashok Kumar Shetty K. for appellant. V. Shivanegoda.
Pass out.
Number 69, P.N. Vishwanatha for appellant.
Up 230. Yes. Yes, 230. Right.
Serial number. Number
Anutraj. Anutraj. ಹಲೋ. ಗೊತ್ತಿಲ್ಲ, ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮುಗ್ದೋಗಿದೆ. ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ನೋಡ್ತೀನಿ. ಹಾ ಹಾ ಓಕೆ, ಸರಿ ಅನ್ಸುತ್ತೆ, ನೋಡ್ತೀನಿ ಹಾಗಾದ್ರೆ. ಎಸ್. ಓಕೆ, ಥ್ಯಾಂಕ್ಸ್. ಥ್ಯಾಂಕ್ ಯು. ಸರಿ, ಹಾಗಿದ್ರೆ ಅದು ಇಲ್ಲ, ಇನ್ನೊಂದು ಏನಾಗ್ಬಿಟ್ಟಿದೆ ಸಿಸ್ಟಮ್ ಸಡನ್ ಆಗಿ ಒಂದ್ಸತಿ ಫುಲ್ ಒಂಥರ ಯೆಲ್ಲೋ ಕಲರ್ ಆಗ್ಬಿಡುತ್ತೆ ಸ್ಕ್ರೀನು. ಹಾ ಅದು ಯಾವಾಗ್ಲಾದ್ರು ಫ್ರೀ ಆದ ಒಂದ್ಸತಿ ತೋರಿಸ್ತೀನಿ ನಾನು.
Disability 3,37,000. What is the income per month? 44,000 ಅಂತಂದ್ರೆ divided by 30 ಎಷ್ಟಾಯ್ತು one day ಗೆ? 1.5 month ಅಂದ್ರೆ 45. 45 plus ಅರ್ಧ 45 divided by 2.
22,500.
45 into 22.
45,000 into 22. 9,90,000. 9,90,000.
Plus 22,000.
5,000 plus 22,000. 67,000.
Yes. ಅಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 44,706 per month. ಆಯ್ತು, ಅದು ಮತ್ತೆ that means 44 67,000 plus loss of amenities ಕೊಟ್ಟಿಲ್ವಾ? Lakhs. ಅಷ್ಟೇ. Will no, that is what that either amenity or disability. ಎರಡರಲ್ಲಿ ಒಂದು ಬರುತ್ತೆ. ಅದೇ ಆ ಹೆಡ್ ಅಲ್ಲಿ ಅಲ್ಲಿಗೆ ಆಯ್ತು, ಅದನ್ನ ಎಲ್ಲ ಸೇರ್ಬಿಟ್ಟು 50-50 ಮಾಡ್ಬಿಡಿ, ಅಲ್ಲಿ ಸರಿ ಆಗುತ್ತೆ. 3,37,000. 1,75,000 will reduce. ಅಲ್ಲಿಗೆ 1 lakh. No, that 75,000, 80,000 rupees for this thing. Yeah, amenities. ಆಮೇಲೆ 75,000 for loss of income. 1.5 ಲಕ್ಷ ಬರುತ್ತೆ. ಅಲ್ಲ, ಅದೇ 1.5 ಲಕ್ಷ ಬಂದ್ರೆ ಅಲ್ಲಿಗೆ ಇನ್ನೂ 1.5 ಲಕ್ಷ ಕಡಿಮೆ. 1.75. ಅದೇ, that is the disability. For that we are granting 80,000 rupees.
Hello.
Well,
Hello.
Shri Ravi Shankar,
Hello.
Learned Council appearing for the insurance company has contended that even though the claimant has suffered an injury, the doctor has assessed the disability. Since he has continued in his service, there is no loss of income due to the disability. The tribunal has error in granting loss of future income due to the disability of rupees 3,37,977. He further contended that the compensation awarded by the tribunal in the other head also on higher side. Hence, he sought for reduction of compensation. Per contra, Sri Gopal Krishna Learned Council appearing for the claimant has contended that even though the tribunal has granted a compensation under the head of disability due to a future loss of income due to the disability, but tribunal has failed to grant any compensation for loss of immunities and loss of income during that has not granted any compensation for loss of immunities and loss of income due to the disability, loss of income during the later period, and also contended that no compensation is awarded for future medical expenses. Therefore, he has contended that considering that all these aspects, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 25/3/2016 due to rash and negligent driving of driver of bus bearing registration number KA 085373. Even though doctor has assessed the disability, even though due to the accident, the claimant has suffered a grievous injury and he has suffered a disability. Since he has been continued in his service, there is no loss of income due to the disability. The tribunal error in granting the compensation under that head. However, the tribunal has failed to grant any compensation under the disability. Considering that injury suffered by the claimant, considering his age and avocation, I am of the opinion that the claimant is entitled 80,000 rupees for loss of immunities. At the time of the accident, he was earning 44,706 per month. Considering that, and he was not attended the duty for a period of 45 days. Considering that monthly income of the claimant as 44,706, he is entitled for a loss of salary for a period of 45 days. 67,059. 67,000. Considering that injury suffered by the claimant and considering his age, the pain and suffering awarded by the tribunal, the claimant is entitled for 20,000 for future medical expenses. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Amount in deposit is transferred to the tribunal. ಏನು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ ಅಲ್ಲ, ಫುಲ್ ಅಮೌಂಟ್ ಮಾಡಿದ್ದೀರಾ ಅಥವಾ ಇಸ್ ದೇರ್ ಎನಿ ರಿಇಂಬರ್ಸ್ಮೆಂಟ್? ಅಷ್ಟೇ, ಹಂಗಾರೆ ರಿಇಂಬರ್ಸ್ಮೆಂಟ್ ಏನು ಬರಲ್ಲ. ಟ್ರಾನ್ಸ್ಫರ್ ಟು ದ if any excess amount, it may be refunded to the appellant. Yes, if the amount deposited by the insurance company is, it's required further this thing, insurance company is directed to deposit entire compensation amount. No, why it cannot be go together. Yes. Yes. Only announcement. Who is appearing for other insurance company? They have not filed any appeal. Regional manager 4, Royal Sundaram 2. Yes. No, anyhow, they have not filed an appeal. Yes, tell. NIM 75. Yes. Now that where is that evidence of the doctor? Now doctor said 69.61% disability to limb, 23.2% whole body. What is the disability tribunal taken? Disabilities they have taken. Now, future prospects, where is that evidence? What was he? What was he? Evidence could. What was his age? 19 years. What was he doing? Cleaner come loader. You will see. I will see that evidence of the doctor, how it will affect your future. What are the doctor evidence? Let us see that evidence. Grade 3 compound crest injury, right foot and ankle, fracture, so dislocation, fracture, medical so. Following difficulties, restrictions of the right ankle movement, difficulty in walking because of distance affected, right ankle so. X-ray. I have above declared that he is my name and signature. What is stated above is to break and best of time. So. Where is the evidence of climate? Yes. ನಿದ್ದೆ ಮಾಡ್ತಿದ್ದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ ಎಷ್ಟು ಅಂತ ಬೆದರಾಗುತ್ತೆ ಮುಂದೆ ಹೋಗುತ್ತೆ ಪ್ರಾಪರ್ ನಾಲೆಜ್ ಸರಿಯಲ್ಲ ಅಂತ ಕಾಯ್ದೆ ಪೊಲೀಸರು ದೂರು ಸರಿಯಲ್ಲ ಎಕ್ಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಸರಿಯಲ್ಲ ನಾನು ಆಸ್ಪತ್ರೆ ಬರೋದು ಸರಿಯಿಲ್ಲ ಅನ್ನೋದು ಹಾಗೆ ತಿಳಿಸ್ಕೊಟ್ಟಿರಲ್ಲ ಫಾಲೋ ಅಪ್ ಟ್ರೀಟ್ಮೆಂಟ್ Yes. No, enough. I have seen that evidence. Yes. What is that? How many days he was in that hospital? Sir, immunities, aspects. Yes, only that disability has to be considered. All other aspects. Yes. Huh? ಈಗ ಎಷ್ಟು ಬರುತ್ತೆ 2018 16 9,500. Yes. Yes, sir. Yes. Then we have to consider future prospects also. Is a young boy, stress injuries and all. It will affect your future also. You see that evidence, but you have not elicited anything from his evidence. Yes, specifically stated. Yes, that's all. 3. Gopal Krishna Learned Council appearing for. No, later period kotilla, but in other hand they have granted sufficient. Amputation. Where is that? No, where is that evidence of the doctor for amputation? Why doctor has not said for amputation? Well, even your evidence is also silent about that. Where is that? Where is that? No, the doctor has to say for amputation model doctor or photographer. Doctor has to say. That is what I read is evidence. Nowhere I have, you just point. Where is that? I submitted that in spite of best available treatment I have. He was following difficulties, restrictions movement. On examination, he has right ankle with this absence of. He is not the doctor who has conducted surgery. He has not stated anywhere that examination restrictions movement on examinations. Any medical record shows that amputation. Absence andre munchene eltididru. That is all the absence. He has to say there is a chances that might be higher. You show me that under the medical records. That's what I am saying. That is what that we have to see now. Yes, crush injury and See, when doctor has not said about the amputation, but if you say absence of grade 2 antandre, it might have been happened earlier. After when doctor has checking, he says that this is an absence, not because of that accident. It has been nowhere that he has said that he has undergone surgery, amputation. Even your evidence is also silent. That's what I am asking. Even that ಅವರಿಗೆ ಲಾಸ್ ಆಫ್ ಮಸಲ್ಸ್ ಮತ್ತೆ ಲಾಸ್ ಆಫ್ ಬೋನ್ ಆಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗಾಯಗಳಿಗೆ ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯಗಳಿಗೆ ಸರಿಯಲ್ಲ. ಡಿಸ್ಚಾರ್ಜ್ ಆದ ಮೇಲೆ ಸರಿಯಲ್ಲ. ಎಸ್ ಎಲ್ಲಿ I Sri Gopal Krishna Learned Council appearing for the claimant has contended that due to that extent the claimant has suffered grievous injury. He has examined the doctor. Doctor has assessed the disability, lower limb disabilities is 69.61% and whole body disabilities is 23.2%. Due to that disability, the petitioner is unable to do his day-to-day work. Since he was a cleaner cum loader, he was unable to do. He has been removed from the service. Therefore, the tribunal has failed to assess functional disability and not granted future prospects. He further contended that the tribunal has, due to that extent, he was inpatient for a period of 14 days. He has suffered a lot of pain during the treatment. The tribunal has not granted any compensation for loss of income during the later period. He further contended that at the time of the accident, he was earning 10,000 per month. The tribunal has assessed the notional income of the claimant as 8,000 per month is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri Ravi Shankar Learned Council appearing for the insurance company as R2 Insurance Company has contended that even though doctor has assessed that disability of whole body is 23.2%, since that the claimant was young boy of 19 years, the fractures are reunited. The disability will not come in the way of his day-to-day work and his avocation. Considering the same, the tribunal has not granted any compensation for future prospects. He further contended that considering that injury suffered by the claimant and considering that evidence of doctor, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties peruse judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 7/5/2016 due to rash and negligent driving of driver of lorry bearing registration number KA 16 C3498 and Isher lorry bearing HR 63B 3363. Ibru mela liability ideyala? Yes. Due to that accident, the claimant has suffered the following injury. He has examined the doctor Praveen HV as PW2. In his evidence, he has deposed that the claimant has suffered compound crushed injury to right foot and ankle. There is a difficulty in restrictions of the right ankle movement and difficulty in walking on a plain and slopes stair, and difficult on standing on an affected limb, and he was squatting and to sit, difficult to sit cross-legged. And the specific contention of the claimant has deposed that he was unable to do his day-to-day work. In cross-examination of PW1 and PW2, respondent has not elicited any worthwhile information. Considering the age of the claimant and considering his avocation, I am of the opinion that he is entitled for future prospects. The disability assessed by the tribunal is just and reasonable. In respect of monthly income is concerned, even though the claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 19 years. Multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Disability 23.2%. Yes.
8,800 at the rate of 40%, 13,300, 13,300 into 12 into 18 into 23.2%. That 96,270.
Yeah. I think agree. Divided by 100. The compensation awarded by the tribunal, in the other hand, are just and reasonable. Yes. Other hand are just and reasonable. Due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 14 days. Considering that evidence of doctor and injury suffered by the claimant, he is entitled for loss of income during the later period for 2 months. 2 months. Other hand, they have granted sufficient. Yes. Yes. So and so insurance company is directed to deposit 75% of that enhanced amount, and so and so insurance company is deposited to 25% of the enhanced amount with interest. Within 6 weeks from date of receipt of the copy of card, in view of order dated 1/9/2021, not entitled for the interest for a period of 206 days.
Number 32, Anant Kumar came for appellant, Mohan BK, Muli Satyendrawal.
32. ಯಾರು ನೋಡಿದಾರೆ ಹೇಳಿದ್ರಂತೆ. What he said? Huh? What is that? Give that file. 32 na? 32. Yes, madam. What is the case? Petitioner entitled for the total compensation from the date. Respondent number 1 is liable to pay the compensation amount to the petitioner. The owner of the vehicle shall deposit. Why that owner has been made liable? Senate Council for Tata Insurance above said ruling of Honorable Gujarat Honorable High Court, when the policy was issued by insurance company had been cancelled as check issued by the insured for the payment of premium must be done of same or be intimated to the insured and concerned RTO. And under such circumstances, the insurance company is not liable to pay that compensation. The check bounce. Yes, who is that appearing for the owner? Yes, heard. Learned counsel for the appellant on IA 1 of 2019 for the reason stated in that accompanying affidavit. Delay of 650 days in filing an appeal is condoned, subject to condition. Appellant is not entitled for the interest in case succeeded in that appeal. Yes. We'll have it on merit next week. Now they will condone the delay.
Krishnaswamy for appellant. 42.
Yes, none appear. Release this matter of next week.
Number 50, Suresh M. Rakhala for appellant.
Submitted matter is there. Serial number? Learned counsel for the appellant submits that this appeal may be called along with that sounds. Yes.
51, Shivakumar Shetty for appellant, B.P. Chivandegowda. Shivakumar Shetty for appellant, B.C. Chivandegowda.
None appear for the appellant. Release this matter after 3 weeks.
Number 69, P.M. Vishwanatha for appellant, N. Srinivasa.
Let me see. So and so. Learned Council appearing for the climate has contended that it is not in dispute. Climate, the owner of the vehicle bearing, owner of the Tata Summa bearing registration number KA05 B3367 has contended that the tribunal has given a finding that Tata Summa has suffered a damage in a road traffic accident due to the negligence of driver of the truck bearing registration number KA01 AB 4559. But the circumstance, tribunal ought to have awarded a compensation for damage caused to the Tata Summa. The error in dismissing the claim petition on the ground that the claimant has, on the ground that the petitioner has violated the policy condition. She further contended that if the insured of the Tata Summa has refused to grant a claim for a damages to the vehicle, is no bar to file a claim petition under 166. The tribunal is error in held that the claimant has violated the policy condition. He is not entitled for compensation for damages to that vehicle. This finding of the tribunal is contrary to Section 166 and 165 and 166 of Motor Vehicles Act. Hence, is sought for allowing that appeal. For contra, Learned Counsel appearing for insurance company has contended that the seating capacity of the Tata Sumo is 6%. They are carrying 8% in that Tata Sumo. It is violation of policy condition. Since the insured of the Tata Suma has violated the policy condition, the insurer of the vehicle has rightly rejected the claim for rejected the OD claim. Therefore, tribunal has justified rejecting the claim petition. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute the claimant is the owner of Tata Suma bearing registration number KA05 B3367. It is also not in dispute the said Tata Suma has suffered a damage in a road traffic accident occurred on 22/8/2005 due to the collision of Tata Sumo and truck bearing registration number KA01 AB 4559 under section 165 of Motor Vehicles Act. It is very clear that the Motor Vehicles Tribunal has been constituted for a purpose of adjudicating upon claim for compensation in respect of accident involving the death of, or bodily injury to, person arising out of use of motor vehicles or damage to any properties of the third party so arising or both. Under section 166 of Motor Vehicles Act, the person sustaining that injury or the owner of the property, legal representatives of the deceased can maintain an application under 166 of Motor Vehicles Act before the tribunal. In the case in hand, it is not in dispute that the Tata Suma has suffered an damages in road traffic accident by using a motor vehicle just because the insurer of the Tata Suma has rejected OD claim, there is no bar for owner of the Tata Suma to file a claim petition under 166 of Motor Vehicles Act. The tribunal has failed to consider this aspect of the matter. The finding given by the tribunal, contrary to section 166, 165 and 166 of Motor Vehicles Act. Hence, the matter is required to be remitted back to the tribunal for fresh consideration. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. The matter is remitted back to the tribunal for fresh consideration in accordance with law. It is made clear that any observation made by this court in its order, the tribunal has to decide that appeal without referring to that any observation made by this court without influencing that any observation made by this court.